to solve the problem, full stop. Then the situation changed because there were really a lot of cases concerning especially dividend stripping and dividend washing, so there were really a lot of that cases that were clearly abusive. That was disturbing, as I think mostly the moral part of judges, or the moral aspect. They started to solve the problem, finding solution in the civil code. We have some provision about to declare the nullity of contract for fraud or nullity for shame, but these concepts are not really, they're not fixed exactly what is an abuse of law in that case, and as consequent, the nullity of the contract is declared, and it's not then a possibility to really recalculate the taxes as the tax revenue wants. So the influence comes from the ECJ Court, so European Court of Justice. There are these three decisions that I pointed out: Carbury, Schweppes, Halifax, and Park Service are really important because from that decision, our Italian Supreme Court decided to take this concept. So the reason for ACJ for using this abuse of law concept, from one side, for what concern the free movement of capital, the freedom of establishment, is a way to ensure the respect for of the fundamental freedoms, as written on the slide, and on the other side. So what on one side, what concern maybe direct taxation. For what concern indirect taxation, so VAT, well, as VAT is an harmonized tax and first income of the EU, of course the European Court wants to preserve VAT as is the first income of the European organization. So important, very fundamental case for abuse of law concept in direct taxation is Carbury versus Carbury Schweppes, and where it's the European Court of Justice states which elements are relevant to see if there is an abusive practice, because very important to remember that the European Court of Justice do not mention any time abuse of law, only abuse of practices that are abusive. In the end, it's the same, but it's like the fear that refers to the concept. So the objective element, it's like it should be a wholly artificial arrangement which do not reflect economic reality. And the purpose was to escape to the tax normally due on the profits. So, despite obviously the formal observation of the law, that's always the basis, and it required also a subjective element. So the intention to obtain a tax advantage. So a wholly artificial arrangement is not enough. So there is also the intention to obtain the tax advantage. I skipped the description of Carbury Schweppes because I think it's very common. So that was for what we refer to direct taxation. For VAT, so indirect taxation, the leading case is Halifax case. In this case, the subject benchmark become less important, and the court pointed out that it should be an existence of an actual advantage contrary to the purpose of the law, and lack of economic reason for the transaction. There is not a sole intention to obtain tax advantage, but an essential aim to obtain this tax advantage. So it's quite less relevant, this aspect. And yeah, what is really important, the European Court of Justice implies this business test. So it's an advice. So what the national judge, every judge of the member state, should apply to verify if a transaction could be defined as abusive. They must prove that the transaction standing a law must be commercially justified. And in that respect, they have to also take in account not only really only economic aspect, but a link of a much more wide and open definition, like the personal nature between, so the relation between the operators involved in the practice, so the legal surrounds, not only the business aspects. But another important thing is to define what is an essential aim, and this was this question. So we have to intend essential aim as no other commercial reason than a tax advantage. This question was ruled by the Italian Supreme Court, in part service case, where they asked to the European Court to explain what is the meaning of this essential aim, and in the European Court of Justice says, okay, part service is always a bad case, so indirect taxation. That essential aim is not to be intended as principal aim, not unique. So it's one of, not the sole intention, not the unique scope of the transaction. So what we can just mention, because there are some differences between direct taxation and VAT. In the sense it's clearer than it's a wideness concept, and the wideness of the concept depends on the context. So if we speak about harmonized taxes or not, and somehow, you know, Halifax and part service as refer to VAT cases, so the transaction standing alone, in somehow part service more maybe than Halifax, respect this business debt, but it was at the higher level, so the group, at the group level, that the mechanism was artificial. But this is a little bit, as VAT is a tax that should be levied concerning every transaction. It's a little bit, yeah, it's how do you say, discutibile, questionable. If you could apply that concept.
With an ECG case, is it?
Yeah.
And what is the year?
Part service 2008. The other was 2006 Halifax and 2008 part service. Yeah, and for direct taxation, it's a more the abuse of law concept is more restrictive. So they need. They require a restrictive element in comparison to the VAT cases. For me, it's not obvious. This is my opinion. That the thing is, as VAT is the first income of the EU, the court just opened his mind and give a bright definition of it. So that all this European discussion is important to understand the Italian one, because when Halifax came out, the judges just refer to the abuse of law concept and abuse of law doctrine that was implemented by the European Court of Justice, and really transposed the abuse of law concept created for a VAT problem to dividend washing case. Simply no. So applying a abuse of law concept born for indirect taxation to a problem of direct taxation. And yeah, you know, direct taxation is not a subject of European law, and yeah, that's exactly. So in this sense, they say the abuse of law concept that was born in that was created from the European Court of Justice is ranking. It's the same as it should be intended as a general anti-avoidance rule that is applicable to all fields of taxation. That obviously creates really a lot of attacks. So really from the entire academics and practitioner world, and and so after this really strongly attack, it was like a slightly change of opinion of the Supreme Court, and they in these three very important decision of the 2008, that was really all the, because the Supreme Court is divided in sections. And when really there are maybe on the same topics, different ruling, different decision, they decided to unify all together the section and give a unique, and it should be solving solution. So also for the contrast in the future. So that is very important. And they say, okay, we can use this concept of abuse of law, so the prohibition of abuse of law, also for non-harmonized taxes or direct taxation, but we don't refer anymore to the European Court of Justice principle, but we can find the same principle in our constitution, Italian constitution, Article 53, that express the ability to pay principle, and they justify this as this provision. It's the basis for all tax provision and exemptions. So in that sense, they say the taxpayer cannot benefit from an undue tax advantage deriving from an abusive practice. So they derive from this principle. But the consequence is that, no, this is practical consequence that that comes out from this new constitutional principle that is applicable in every stage of the proceedings, so every instance, ex officio, directly from the judge, and the burden of proof remains to the tax authorities. That's clear. But in case of lack of economic reason, the taxpayer has to prove the existence of valid economic reason for the transaction, and if the transaction is declared abusive, is recalculating according to the legal form that should have been applied in the opinion of the Tax Revenue Service. Then, the reaction were also to this important decision. There were a lot of reaction from practitioners, academics, because they say, this Article 53 is a constitutional principle, as it's not a substantive provision, so it cannot be applied directly, and it needs to be implemented by statutory provision. And our problem is, is this approach compatible with the principle of legality expressed in Article 23? Because in this way we apply. It's very borderline the things, because you are taxed with that new rule that is not written in the tax code. So that's very, very borderline. And in this sense, the problem is, as we have a civil law country, and in this sense the court is making the law. So it's something that in this way tax authorities and also the judges are empowered to select and give relevance to certain situations that for justifying taxation, and this is in conflict with the saving clause of Article 23 of Constitution. But there are, this was the first approach. Now, in the years, the court developed like a self-restraint or opinion for himself. So try to put up some wall, to build up some wall, because otherwise, really, the tax authority in the last year just referred immediately to this principle when it was not possible to define other ways the transaction. And there is this important case from 2011, where in particular, when some multinational enterprises are involved in such tax control, the court said, okay, the tax revenue service, you have to be really attention, to pay really particular attention in the application of this abuse of law principle in case of company reorganization, because in the field, multinational enterprises, the transaction that these companies applies are not immediately aimed to generate profit, because there are many other reasons, managerial reasons, financial, organizational. There are a lot of reasons, and it's not like, okay, we have to earn and immediately to have an economic return or reflection for our transaction. So that could be, it's in this really big company, it's quite normal. And in this sense, the tax authority shall verify the compatibility of this operation, this transaction, with the regular market logic. And for the future, we have to wait some explanation. As this is my opinion. This is really my opinion. As in somehow the court doubt of his explanation, because it submits two reference for preliminary ruling to the European Court of Justice, that are these two from 2010. They regard dividend washing and dividend stripping, so direct taxation, that was affecting cross-border transaction within the EU. But the question is, could the abuse of law principle elaborated at European level extending to non-harmonized taxes? So, in my opinion, why to ask the European Court of Justice on a field that is not his field? That it's like the court need like a supranational justification for the application of this principle. That's really my personal opinion, and not, but yeah, that's it. And this is wonderful San Marco Square with high water in Venice.
Under the water.
Yeah, this is high water in Venice.
You're gradually making us be louder.
Exactly.
Yeah.
Another message underlying the presentation. So thank you very much. As a matter of fact, as you know, I involved Stefania to make. She worked more than I think all of us taken together. She delivered a full presentation on the Italian side, and thank you very much for this. Well, let's hear immediately to the reply from Kazakhstan to this presentation from Italy.
I apologize, that being not in order, but I have class, that's why.
Your presentation should
Special.
If we were on television now, I would say it's time for advertisement.
Yeah.
When the communication stops all of a sudden and some advertisement is shot in order to recover some time.
Marco, maybe you can continue. Sorry for.
Okay, let's do it this way. As soon as she's back with your presentation, I will stop. Because I can easily split my presentation in two parts, and in any case do it very, very, very quickly.
Thank you, Marco.
Even if because my presentation is in fact the second time of the movie that Stefania already has been showing you for the first 15 minutes. What we understood from Stefania's presentation, we understood that the anti-avoidance system, the anti-avoidance in Italy has been implemented through the use of specific anti-avoidance rules. Most of them are in Article 37 bis, that means double, of Decree 673. You got a USB pen, Senia?
Huh?
I've got her presentation by chance.
She didn't send me her presentation.
Okay.
Okay, we'll mark it.
Okay, keep on going. Okay. And as Stefania told you, we also have a judge-made GAAR, General Anti-Avoidance Rule, and the abuse of law doctrine that Stefania Martinengo introduced to you. Basically speaking, there are a close number of operations that our legislator considered to be abusive, elusive, in avoidance of the law, and these operations are listed black and white in Article 37 bis Decree 673, close number, those mentioned there, no more, no less, plus a general anti-avoidance rules, which is clearly written nowhere, but that our Supreme Court thinks that can be understood or derived from the general principle of our legal system. Therefore, no legal certainty in this respect. Quite dangerous feature of our legal system, particularly for what concerns foreign investors. And Stefania already told you about the EU influence on that. Double taxation conventions. We already talked a lot about that. Sorry for the mistakes. There are a few mistakes in this slide. No specific anti-avoidance rules, but the possible limitation of benefit clause that is present here and there in a lot of the convention, including the convention between Italy and Kazakhstan. This attributes the state a remarkable leeway, freedom to apply their own specific provision. Limitation of benefits, of course, I already told you about that, and beneficial ownership test. I want to take you just a few minutes. I will skip the comments of articles of the OECD model because we already talked a lot about that. I just want to take a few other minutes to comment with you a case, Article 5, permanent establishment, protocol to the convention. Yeah, just to give you an idea, a very practical idea of how the beneficial ownership clause work. This is a case that we commented already last year in Astana probably, and even here in Almaty, that was decided by a local court last year in Turin. Some of you although probably remember this case. This case is the decision of the Tax Court of Turin, decision 100/2024, decided on October 19th, 2010, the so-called Taxid case, because it was decided and after having taken into account a taxed corporation that is a part or a corporation in connection with the Fiat group, the other Italian multinational. I don't think it's very active here in Kazakhstan, but anyway, it doesn't matter. Taxid works for Fiat. Taxid provides some specific component to the Fiat group in order to prepare their, of course, car and probably trucks and a lot of other things. Well, the problem was for us that the Taxid structure was quite simple, with an holding company, Taxid SPA, upper left corner of the slide, owning another company, Taxid SRL, another limited liability company, so to say, both resident in Italy. The first one was an holding company, the second one, the business, the operative company. 100% was the control. The Taxid SPA was owner of the patent, the technologies, the trademarks, many other high-value intangibles. Taxid SRL, subsidiary, controlled company, did the hard work. That is, created actually the pieces to be sold to the Fiat Group. Then they decided that to enter into a quite, I would say, quite aggressive, perhaps, tax planning scheme, and they transformed their group from this very, very simple situation, two companies, into this much more complicated structure involving a number of companies, at least 5 of them, but there are many others that I didn't mention in this slide in order to make it more simple. The point is that to understand this mechanism, we have to begin from the center, from Taxid Lux, a company resident in Luxembourg. To that company, the Italian partner attributed the intangible. You see the trademark, the Texid mark. The Texid trademark was given to them. On her side, Texid Luxembourg was controlled by two other companies, Texid SARL, resident in Luxembourg as well, and Texid Bermuda, resident in a tax haven. So that was the structure of the Texid group. What is the point of the situation? Look at the bottom right corner, Texid SRL. They keep on doing the same job they have been doing for years and years. Manufacture specific component, bumpers or others, I don't know, of the Fiat cars. Keep on doing that in Italy. The point is, they transferred trademarks, patents in Luxembourg, and now Texid Luxembourg asks for royalties to be paid in order to license Texid SRL to use that technology. Royalties were actually paid. You see the yellow line going from Italy to Luxembourg. The point was here the application of the double taxation convention between Italy and Luxembourg that was used by Texid to reduce the amount of withholding tax at source on the flow of the outgoing royalties. So basically, if that was the scheme, the question was, is Texid Lux the beneficial owner of the flow of royalties paid from Texid SRL? And moreover, can it qualify for the application of the double taxation convention between Italy and Luxembourg? So this case, in my opinion, was and still is very interesting because it provides a solution, a straightforward answer to a number of endless theory that you find in books, in articles, in academics discussion. The answer is yes or no, and we'll see in a few seconds that the ultimate answer was no, it is not what the beneficial owner. The decision was relevant in this case because without a double taxation convention, the withholding tax rate is 30% for the royalties outgoing from Italy, somewhere, wherever around the world, including Luxembourg. In the case of double taxation convention to be applicable, the royalties drop down to 10%, so a remarkable difference. First of all, in our experience, it's not only a matter of substance, it's also a matter of procedure. Look how the Italian courts generally treat cases like this from a procedural point of view. Who has to demonstrate what? The central part of this slide, between bracket, of course, is copied and pasted. That was in Italian, I translated it in English, but the sense is like that, of the motivation of the court. The court is the opinion that the burden of the proof is on the taxpayer when she asks for the application of specific advantages that wouldn't be otherwise attributed. So the burden of the proof, obviously, is on the shoulder of the taxpayer. It is the taxpayer who has to demonstrate to be the beneficial owner. It's not the revenue service who has to demonstrate that the company is abroad, is a stepstone company, is another holding company, or whatever else. And what were the facts considered relevant by the Italian tax court in this case? First point, the trademark Texid was licensed for free from Texid SPA to Texid Luxembourg. The trademark was not born in Luxembourg. It was transferred in Luxembourg. And in order to transfer this trademark, the Texid advisors suggested the company to license it for free. In my opinion, perhaps not the best solution, but that's very personal. Moreover, Texid Luxembourg is fully controlled by non-resident companies. This is the second aspect that the court emphasized in this case. Moreover, Texid balance sheet, there was an exchange of information, revealed that the company owns only intangible assets. Therefore, what is the situation? The situation is that we have a company resident in Luxembourg that owns nothing but the trademark, that enjoy that trademark for free, and eventually that is fully controlled by non-resident companies. These are the three features of the case we are discussing now together. And in the light of these three features, why this Texid Luxembourg is not a beneficial owner according to the Italian taxation law? First point, as I told you, Texid obtain the intellectual property for free? Well, they didn't give money from Luxembourg. No money from Luxembourg to Italy. Second point, Tex in Luxembourg has got that trademark and that trademark only. There's no clear business. There is a clear disproportion between the cost incurred, 61,000 euro per year, and a little more, so therefore the salary perhaps of 1 or 2 clerks or accountant over there, and the earnings, 14 million euro. The matter of disproportion matters between profits on one side, for royalties on one side, and costs on the other. And eventually, the status of subsidiary of only one non-resident company. Tex Bermuda owned, you remember from the slide, 99% of the shares of Tex Luxembourg, making Tex Luxembourg, of course, more than a subsidiary in the eyes of the Bermuda controlling company. Why this case is so important? I think that I can finalize my presentation over here in order to speed up the last part of the afternoon session. The case is so important because, well, the Italian approach, as you see, there is a number of ways that can be followed to combat tax avoidance or tax evasion. Italy generally choose the formal approach in this respect. Beneficial owner, in our case, means the legal owner. And to a certain extent, for us, once the payment is made to an entity and the sum belongs to the assets of that entity, there's no ground to consider the entity as the non-beneficial owner. In other words, this case is so important because for the first time our court seems to abandon the formal approach that generally is our jurisprudence is inspired by. Generally speaking, the Italians say, well, look, if a company is incorporated, it does exist, it's not a stepstone company. If the payment is made, we can trace back a wire payment bank to bank from one point to the other, then there's a sound business over there. Very formal in this respect. But in this case, according to the reasoning of this case, now the Italian tribunals, the Italian court, to be more precise, seems to be more open to a concept of beneficial owner, which is more inspired by OECD guideline on one side, and by an approach which is more belonging at least to the common law countries or to the United States or the United Kingdom, perhaps. So it's making substance, as a matter of fact, to prevail over a sophisticated tax planning scheme that could have been arguably better implemented. Well, there is some observation, Article 29 of the Double Taxation Convention, but I already took more or less 15 minutes, and I prefer to stop here. Thanking you for your attention until this very last minute.
Actually,
Now you got the USB. There we go. And now, after a quick trip to Italy, goes back to Kazakhstan with the same issues and the same approach by Alina.
thank you, Marco. Actually, in Kazakhstan, we do not have general anti-avoidance rules. Otherwise, on the other hand, we have special anti-avoidance rules. And very briefly, I will provide you with the provisions we have in our legislation.
Sorry.
Okay, and here's the content of my presentation. We will start from transfer pricing. One thing mentioned is that in Kazakhstan we have a separate law on transfer pricing. Yes. The next one is controlled foreign company or tax haven matters. Thin capitalization, we have such kind of rule. Beneficial ownership, we have a provision in our tax code, which, by the way, was amended in new version of tax code. And the last one, which I would like to discuss, is limitation of benefit clause. Starts from transfer pricing. I guess everyone knows what it is, but why I decided to use this definition is to show that in Kazakhstan actually we have a little bit, we have another definition, which means that I will read it and show the difference. Transfer pricing is a term used to describe all aspects of intercompany pricing arrangements between related business entities. And here you could see the Kazakhstani perspective. It means that transfer pricing means the price which is established between mutually dependent parties and the price which is different from the impartially established market price, taking into account the price range when the transaction is made between independent entities. And such price is subject to control in compliance with this law. Which means that a little bit in Kazakhstan we understand transfer pricing a little bit different than in the rest of the world. Yes, actually here it just covers that all intercompany pricing arrangements, and here it is that mutual.
So basically that means that even the prices in the transactions between unrelated parties could be controlled as well. If the tax authorities will suspect that prices are deviating from those at arm's length, or as we usually hear the term, market prices.
Thank you, Vladimir. And here you could see the control of transfer pricing, on which transactions the control of transfer pricing is spread. First one, it is international business transactions, transactions executed in the territory of Republic of Kazakhstan, subject to their further relation to international business transactions, for remarkable minerals produced by party subsoil, with the party enjoying tax benefits user, and with the party suffering a loss as indicated in tax statement for the last two taxation periods preceding the transaction year. Actually, these transactions are covered by the transfer pricing law. Transfer pricing methods which are used in our country is comparable uncontrolled price method, cost plus method, resale price method, profit distribution method, and net profit method. And one thing to mention is that you could not just apply each of them. The method is that if the first one doesn't, you can use the second one only if the first one, if the first method could not be applied. And if etc. if the second could not be applied, you use it.
Hierarchy.
Hierarchy, yes. And here you could see the documents required. First one is report on transactions monitoring, which include documents supporting the grounds for price application, the method used to determine the market price, the source of information used to determine the market price, the description of goods, the contractual terms and conditions, strategy of business transactions management, and commission fee of a trade broker. Sorry for this one, it's pink.
Oh.
It's just some. Yes, the next one is controlled foreign company or tax haven matters. I would skip the slide which explains what what does controlled foreign company means, and I will start from Kazakhstani rules. And for the first time, the rule was implemented in 1995 to our tax code in Article 39, individual and corporate income. Later, it was amended in 2002 and was mentioned in Article 130. And currently, it is the rule is mentioned in Article 2 to 4, and actually you could find it in your handouts. And I will read the provision. Here you could see that the threshold to the evolution of the tax code changed from 20% to 10%. And now I will read the provision. A non-resident located or registered in a country with privileged taxation shall be a non-resident legal entity simultaneously meeting the following conditions. First, it is registered in a country with privileged taxation. 10% and more percent of the authorized capital or voting shares are directly or indirectly held by a resident of the Republic of Kazakhstan. A part of profits of non-residents located or registered in a country with privileged taxation shall be included in the taxable income, and where taxable income is absent, it shall reduce losses of the resident of Republic of Kazakhstan, which directly or indirectly holds 10% and more percent of the authorized capital of or voting shares in such non-residents. Provisions of this paragraph shall also apply to residents' participation in other forms of organization of business activities which do not form a legal entity, where participatory interest makes directly or indirectly 10% or more percent. Also, what I would like to mention as well is that Kazakhstan has formed a blacklist of the countries, and it is. I could send you the document of the blacklist listing all the countries in both languages. And also Article 4 specifies the following. I find very interesting paragraph 4, where it is stated that a foreign country or its administrative territorial unit shall be recognized as a country with privileged taxation in the event that they meet one of the following conditions. First one, in such a country or administrative territorial unit, the income rate is less than 10%. Second, such a country or administrative territorial unit has laws concerning confidentiality of financial information or laws that allow observing secrecy in respect of the actual owner of property, or income owners, participants, founders, shareholders, or a legal entity. Basically, and this means that even if the country is not listed in a blacklist of Kazakhstan, but still it is covered by these provisions, it would be considered as a country with privileged taxation, and the income would be CFC rules. And also we have a thin capital income rule. It is in article, also you could see in your handouts, article 103. Also I will skip this explanation of what is thin cap rule. And now I just want to say that according to our rule, the limiting coefficient for financial organization shall be equal to 9%, and for other legal persons 6%. I will also skip the reclassification issues.
Question, question, if I may take a few seconds of you. Because in the CFC, you told me that the CFC kicks in when 10% threshold.
10 or yes.
And how can you calculate the tax on an income which is determined according to our another system? I mean, let's assume that a company in Kazakhstan controls a subsidiary in maybe another state, China, let's assume, and you want to apply CFC rules. Just the first thing that you have to do is to calculate the taxable base of your subsidiary in China. And you do that according to the rules that you have in Kazakhstan or the rules that you have in China. In Italy would be rules of Italy. CFC provision wants you to get part of the income of the subsidiary and recalculate it according to the tax law of Italy. Is the same in Kazakhstan or not?
Vladimir, could you help us please to solve this issue?
It's very, you know what's the problem, which is there is an ongoing discussion on this in Italy as well, because other people are very angry about this solution, which is very complicated. The point is, in Italy we have CFC regulation, and that's okay. CFC means that a part of the income of the subsidiary is attributed to the controlling company in Italy. But that's fine. Which part of income? It's easy. The part of income which would be attributable to you according to your shares. So if you have 60% of the subsidiary, 60% of the income is attributed to you according to the CFC rule. But the point is, how or under which rules can you calculate the income attributed according to transparency? Do you follow the rules applicable in the other state, or do you have to calculate income according to the Italian rules? The point would be simple. Let's assume that you have a subsidiary in the Cayman Island. Cayman Island means zero taxation, zero income, nothing of that kind. If you apply CFC regulation, you get 60% of nothing. So you get no taxable income. That's why Italy wants the Italian company to take the balance sheet of the subsidiary and recalculate on that balance sheet the income according to the Italian rules and get a percentage of that. There's an ongoing debate on this in Italy because a lot of people say, well, it's a double work, you have to work very hard, and we are against. Vladimir, what do you do in
Alina, could you please put here that Article 224?
You have it in your handouts.
On handout. So one may follow it here. So, okay?
Yes, Vladimir, there is actually, I guess that it's the same.
Because if you follow in the article, they have the special formula even how to calculate it.
okay.
You have also handouts, so you could.
Oh, yes.
Yes. The article is
Article 224.
Yeah, there are some formulas.
You could see.
Some formulas,
Okay.
like for apportionate,
Like
like
here.
it has P1,
What
P1.
is this one?
And
224.
so using the formula to look at it briefly, there are like a number of entrances which and the share is affected not only by share but also there if you could see there like in indirect participation like a number of months and so on.
Any question? Okay, and talking about beneficial ownership, in Kazakhstan, as I already mentioned, here you could see just their brief history when this term was introduced to the OECD commentaries as well as to the OECD model. It was in 1977, and the reason was mainly to counter treaty shopping and to clarify their wording paid to, and it's just a brief. And here you could see where in convention we could find this term mentioned. It's Article 10, 11, 12, dividends, interest and royalties. And here on this slide you could see the main problems which arise, which concerns this concept. And mainly, of course, this is lack of understanding. And as for civil law countries, most of them do not contain the term in their legislation, and otherwise no consensus has been reached so far, either apply international fiscal meaning or domestic one. Questions still open, but in Kazakhstan we have a clear definition of the term, and it is also, you can find it in your handouts, and this is Article 212, paragraph 212/1. And I will read the provision. For the purposes of this section, the final actual recipient owner shall be understood to mean a person who has the right of possession, use, and disposal of income and is not an intermediary with respect to such income, including an agent and nominee holder. Which I find very interesting that this provision resembles us OECD commentaries. It's like, and also another interesting thing is that in civil law countries we don't have a division of ownership. It means that legal owner, yes. However, in common law, where this concept is takes its origins, they have such division, and currently in our tax code you could see that they say that who has the right of possession, use and disposal, they try how to make this more or less understandable to which kind of ownership concept applies. And the last one is limitation of benefits clause. This is also an anti-abuse provision which is used in tax treaties, and as an example you could see the one we have in Italy, Kazakhstan, tax treaty between Kazakhstan and Italy, and I could read it. A person that is a resident of contracting state and derives income from the other contracting state shall not be entitled to relief from taxation in that other state otherwise provided for in this convention if it was the main purpose or one of the main purposes of any person concerned with the creation of assignment of such item of income to take advantage of the provision of this convention. It means that it looks for the purpose of and tries to, like is prescribed in Vienna Convention, to interpret it in the light and the object of the convention. Such kind of limitation. And also we found in Canada like limitation of benefit clause, and you could read it if you're interested in handouts. I would not read it now due to the lack of time, but still. And in Spain, Kazakhstan tax treaty, we also have interesting provision. And for me, because I'm writing my thesis on beneficial ownership, it's very interesting that in the first sentence you could see that it is understood that the benefits under this convention shall not be granted to a person which is not the beneficial owner of the items of income derived from the other contracting state or the items of capital situated therein, which means that beneficial ownership concept applies not only to articles as usual 10, 11, and 12, however to all kind of income, which actually, because it is also a debatable issue whether this concept should be applied to the whole convention or to these specific articles. And the other part of this provision basically states that Article 10, 11, and 12 could not be applied if the purpose was to abuse tax treaty also, to abuse the provision of the tax treaty. Actually, this is all with my presentation. Thank you for your attention.
Could I raise one more issue about
on the anti-avoidance provision that you have in your system? I understood there are a lot of similarities with our own, particularly for what concerns, CFC, transfer pricing, and all the other instruments that are almost nowadays standard. So far away, but yet so close as a legal system. Okay, so
thank you. Vladimir, you had a question?
Yeah, a question about Article 224. So, Marco, you saw the provisions there, long formula and so on. And now there is a tricky point. They are effective since 1st January 2009, but they were introduced in the middle of 2011. So now basically the practical implication. What if companies used the provision but calculated the shares differently in the years like 2009, 2010? So what will happen to their calculations there?
And what is the answer? What do you mean?
So
we are all interested in.
So basically, I'm wondering myself.
You mean what is the? I could give you perhaps the answer in the Italian perspective.
Could be answered in Italian perspective, and if for practitioners met such a situation, what could be the answer given by Kazakhstani authorities of practice?
In the case of, you mean, of sale of shares in order to avoid the application?
No. In case that if that was a pending situation throughout all the years.
Okay.
So for 2009 and 2008.
Yeah. So that was
sorry.
Yeah, that was the amendment introduced with backward force.
Yeah. The previous provision.
In Italy, generally, we don't have a retroactive effect of the law, and we freeze the participation, the amount, the shares, the percentage at the very last minute of the fiscal year, and in order to avoid dismission of the shares or other operation of that kind, we implemented one specific anti-avoidance provision empowering the revenue service to disregard sale of shares made without other business purpose, but the non-application of the CFC provision, if this is the answer from the Italian perspective.
Oh, great, thanks.
So no retroaction. Look at the very last minute of the last day, and anti-avoidance provision to be used in order to neutralize any self-share transfers or whatever.
Well, great.
This is the Italian perspective.
Thank you.
Thank you for your presentation. Okay.
The last one is taxation of capital gains.
Yep. This way.
Hello everyone. I'll try to make the presentation quite fast, so not to waste much of your time. But today I wanted to talk about capital gains, extraterritorial taxation of capital gains in Kazakhstan. And to my understanding, the primary purpose for introducing of this type of extraterritorial taxation was to capture possible tax avoidance in respect of subsurface users, because for Kazakhstan it's very important. Many companies can try to avoid tax just making holding companies outside of the territory of Kazakhstan. So Kazakhstan is trying to capture all transactions which well, primarily it was trying to capture all transactions related to subsurface users, which even were outside of Kazakhstan. And this is my outline. And now we'll start with definition. What I think is quite important here is because Kazakhstan regulates the price of assets based on, we'll use transfer pricing law to regulate the price of assets which are sold. And therefore, if you read the definition of capital gain, it's positive difference. First one is positive difference between sale price and historic cost contribution, or the second one, if transfer or contribution to authorized capital is the difference between the cost determined in accordance with civil law legislation of the Republic of Kazakhstan and historic cost contribution. Well, second one actually can be captured with transfer pricing legislation, but the first one, if you make a sale and the sale is made outside of Kazakhstan, the transfer pricing law of Kazakhstan does not capture this transaction. Therefore, if you make a kind of sale between related parties and there is no cross-border transaction, so it's pure outside of Kazakhstan transaction which is made at historic cost, therefore capital gain can be avoided. So if you have a company which costs billions, but your historic contribution was like 100 for this company, for the shares of the company, you can sell again for 100 to your related party, and there will be no capital gain. Articles from 190s regulate income of non-residents in Kazakhstan, and it basically describes that Article 192 outlines 4 points when the capital gain arises and it should be taxed. However, it's quite unusual, but still, next article actually exempts this kind of income from taxation in Kazakhstan. Well, that will mean actually that why these articles are not eliminated, maybe taxpayers may expect that allowances under Article 193 may be later abandoned, and these types of income will be taxed again. Otherwise, we have capital gain that should be taxed, and another article says, okay, it shouldn't be taxed. Yeah. But still, which is important now, this is new rules starting from 2012, which imposes the criteria under which the capital gain can be exempted. So the first one is 3-year holding period. Once a non-resident buys shares or assets in Kazakhstan and holds them for 3 years, further sale of these assets, it sells these assets after 3 years, capital gain arising out of these assets can be exempted. Well, why this was introduced? Because to attract investments in Kazakhstan, the bigger investment, the better, but to avoid trading, to avoid the, I would say, constant trading or attempts to tax avoidance, but to keep some money in Kazakhstan. Second one is there is no exemption allowed for subsurface users. So if the company which issues shares is a subsurface user, the sale of assets of subsurface user cannot be exempted under any condition. And this is the third point, the third criteria is when one company, actually holding company outside of Kazakhstan, hold shares in a subsurface users, and more than 50% of the non-resident of Kazakhstan is derived from a subsurface user in Kazakhstan, the sale of the shares of this subsurface outside of Kazakhstan should be also taxed in Kazakhstan. And new Article 197 outlines the types of shares or assets which fall under the, which should be taxed, sale of which and capital gain made out of which should be taxed in Kazakhstan. So this is assets situated in the territory of the Republic of Kazakhstan, the right to which or transaction which are subject to state registration, assets situated in the territory of Kazakhstan which are subject to state registration. So that could be just asset or just shares. Sale of shares, any transaction should be registered. Then shares issued by a resident and participating interest in authorized capital of a resident legal entity, that is subsurface user or consortium in which a subsurface user is a participant. Well, basically, if a subsurface user issues the shares, and then any capital gain on sale of the shares should be taxed in Kazakhstan. shares issued by resident and participatory interest in authorized capital of a resident legal entity if 50 or more % of the value of authorized capital or of the shares in said legal entity or consortium is assets of a person which is a subservient user. So basically the same rule which we just described. If non-resident holding company has assets in subservient user and more than 50% of this non-resident value derived from a subservient user in Kazakhstan. Well, basically the 4th and 5th rules, they almost coincide with these. And now it's very important to determine the tax agent in Kazakhstan. You can understand that if a resident of Kazakhstan sells assets to a non-resident of Kazakhstan, it's quite easy to withhold tax from a resident of Kazakhstan. But the situation may be when both parties to transactions are non-residents in Kazakhstan. Well, therefore, the rule basically the same. The buyer of the assets is responsible for withholding tax and contribution of the tax of the amount of tax to the budget of Kazakhstan. And the well, in case the amount will not be transferred to the budget of Kazakhstan, the tax authorities of Kazakhstan may attempt to seize the property or assets which are located in Kazakhstan. And then, well, it can be the sale of these assets, or they may arrest the assets to withhold the tax. And basically, that's why the extraterritorial capital gain applies only to shares or assets which are either physically located in Kazakhstan, like real estate, or to the assets, the transaction to which are subject to state registration. For example, we have a participation. We have a rule related to subservient users. It's preemptive rights, and therefore, any company, if you sell a share in a subservient user, you should register the sale. The registration of the owner of subservient user, or the person has right for a subservient use contract. And therefore, if the one company sells the right to use the contract to another company and does not register it with the relevant state body, the transaction will be void. Okay. And then they can actually trace any kind of these transactions. Yeah.
But also the taxes on the registration, maybe lump sum taxes.
No, not really. Some very small. Yeah. Well, this another very important issue. As you know, capital gains can be exempt under tax treaties. The tax on capital gain can be exempt under tax treaties, but it's not possible to make it automatic, like with dividends or interest. The only way to get money back is through refund in Kazakhstan. Therefore, the resident or the agent is supposed to withhold the full amount of tax, which is normally 15% under domestic legislation. Then it puts the money to the deposit or to the bank, and then the person who has right to get these funds back under a tax treaty is supposed to apply to the government of Kazakhstan and ask for refund. And normally this procedure lasts for 6 months, but we see cases when it lasts for more than 1 year, because they can stop for audit, they can stop for some period, the tax authorities may perform tax audit to see if the transaction was proper or not. And well, normally this is very long-lasting event. And this the point is there is no matter. The point of the slide is there is no matter in which form the transaction was made. Was it monetary form, or if in the second case the price was the assets were contributed to a charter capital and there was increase of value determined by the civil law of Kazakhstan, the agent is responsible for withholding and payment of the tax to the budget of Kazakhstan. Well, I discussed the responsibility to withhold. Yeah, and well, that's all for Mr. Tutor taxation.
Okay, I don't have a question concerning your presentation, but actually the taxation of capital gains is really one of the hottest topics in Italy as well. We changed the law. We're talking about that in these days a couple of times in order to intercept the capital gains that would be otherwise lost when realized broad.
But do we also have extraterritorial taxation?
No. We implemented the rules this morning in order to consider resident in Italy, the companies resident abroad. So we didn't intervene on the capital gains taxation extraterritoriality rules, because at that time the revenue service, their chief inspector told me that it would have been too difficult for two reasons. First, double taxation convention enforced that prevented us for free hands on that. Second, EU provision that would have been maybe against this kind of recapture. And so, also for these reasons, policy reason, political reason, I don't know, they prefer to focus on the companies, to use the broad to develop this kind of operation, considering those companies present in Italy when they only do that kind of trade. So if you're a company abroad and you only are involved in this kind of transaction, then as a matter of fact you're resident in Italy.
Oh yeah, okay.
And therefore we capture also the capital gains. So
it,
I mean, a longest road that we do to reach your target, in the conclusion, that we chose to walk through because the direct way would be perhaps not so feasible, so possible. But the kind of problem is that.
But here also they say that all constructions or installments related to subsurface uses are treated as real estate. So in double tax treaty we say that the assets determined in Article 6, was it real estate?
Movable property.
Yeah, movable property, and well, we also determined that in accordance with domestic legislation, which is real estate.
Yeah, I got it. The problem is in Italy we don't have. Yeah, we have surface use, but not as much as in Kazakhstan.
Yeah, for us, it's
and we got the same problem with other assets for whom we cannot apply Article 6.
okay.
Thank you very much. Thank you indeed for your presentation. Other comments on this presentation? No, if there are not, so thank you again for your time. Okay, Senia, what's next?
Next is prizes, congratulations,
So
words of appreciation.
it's closing time. Oh God. At the end of the day. Well, let's do just add maybe a few words, a few comments. Vladimir, just to close this. Well, this procedure, these 2 days have been very. Just a few comments on my side, and please add a few on your side. Well, the laws of Charles Darwin. At the end of this natural selection, only the toughest guys survive, and yes, of course, a lot of friends have had to leave this room because of their commitment, because of their involvement in the other courses and here in the university life. Taxation law is very important, but it's not the only topic that you have to study in order to graduate. It's part of life, and we perfectly understand this. Generally speaking, I'm used to say to my students and to my friends in Italy that I'm not very good at the speeches at the end of the conference. That's why generally I do not have speeches or toast at the end of the conference in order to avoid some sort of embarrassment on my side. But I just want to thank you again, Senia, Vladimir, and of course Thomas Balko is somewhere in other country. His spirit is amongst us, but his physical body is somewhere else. For your hospitality, that's been really good, great, fantastic, outstanding, and I don't know how to describe that in English. I think that these have been 2 very interesting days, fruitful for me. I learned a lot from you, from all of your presentation, from all the slice of the taxation system in Kazakhstan that you introduced to us. Probably Thomas Balko will talk to you about this, but I just want to anticipate that it's my intention to write something on this topic in Italy. Our idea is to write a commentary of the double taxation convention between Italy and Kazakhstan and make it available to the business community in Italy, and maybe, if interested, even to the business community here in Kazakhstan. So it's one of our policy guidelines in Ferrara to prepare something written on paper of the events that we had. Otherwise, the risk is to waste the richness of the information, to waste the quality of your studies, to waste the straightforwardness of your presentation, and we don't want to do that absolutely. So let's keep in touch. We will. I'm pretty sure that, but let's keep in touch very soon for that. And I do hope see you in Ferrara as well. The next forum shall be in Ferrara at the end of June, when we'll be once Italian summertime will be at its best, more or less. So hot weather, friendly climate, etc., etc. I'm pretty sure we will not be able to match the quality of your hospitality, but we will do our best to be at least acceptable. So thank you again, and very much for your help.
Yeah. Thank you for the final speech. Thank you for organizing the conference with the Italian perspective. And indeed, as you told about some ideas which you just suggested several plans to realize, like commentaries to Kazakhstan Italy Convention. Actually, I believe that this international forum reached some of the goals are both planned and not really planned in advance, because even during previous days there were suggestions like commentaries and ideas raised from different participations, and some valuable additions from Tom Balko, who is out there, and we also as Cataract we have some additional plans to research. But research is one thing, another thing is literally communication. And I was really glad to see many professionals which gathered in the room, both from Italy, from Spain, from Kazakhstan. And I mean, I was really surprised when I saw so many representatives of business communities. So I hope you saw some interesting points, and the forum will be useful here as well. So I'd like to thank all of you, all of us here in the room, and those who for some reasons are not here with us, because basically the forum that was us, those we who gathered here and exchanged the ideas, the experiences, and contributed to the result. So I think now I should give some words. I think I should give the word to Ksenia, who apparently had presented, had prepared some of maybe surprises over there. I just don't really know what is in there in the box. Wow. She brought here.
Scrolling.
Надя, принеси, пожалуйста.
Dear Marco, dear Vladimir, thank you very much for your words appreciation. I'm very happy that we managed to hold this forum, that it was interesting not only for students to participate, for academics to present, and also for the business community to probably learn something about the perspective of the other countries. I mean, not about the Kazakhstan, but about the Italy, as well as for Italians to learn a bit about the Kazakhstan perspective. I hope it was beneficial and practical, helpful for everyone. And in the end, we didn't give any certificates because we forgot. I will bring it to you. Actually, we were preparing the certificates for you, but instead of certificates, I want to present you now the photo album with the comments and notes from all our team, with photos we have during this week. So you could put it in your center. Like in our center, we have posters with the photos and notes. We want this photo album, reminds you about time in Almaty. And there are a lot of foreign words that people are telling to you. And during the evening, we will also fulfill with the people who also will come. There is no time.
Yes, that was good.
And also I have presents for all our participants, for all our guests. It will be like a symbol of Kazakh for Euroball, with our symbol of Kazakh and Kima. So how will what colors do you want to get? There are lots of them. I think Nadia will help me.
Yeah, I think bronze is good for Stefania.
Thank you very much. Thank you very much. Really.
And also green one, red one. Which would you like? According to your brightness of your presentation.
Bellissimo. Wow.
Yellow as well.
Yes, it's fantastic.
Have you taken
You printed them in real time. Wow, it's more than beautiful. I really, I don't. Oh, yeah.